Statement of the facts. Reverend Tyrone Smith, appellant, was a lawful resident of 222 North 2nd Avenue at the time relevant to this appeal. The roommate arrangement arose when petitioner, Ms. Shabazz, fell short on rent, and appellant contributed $300 June and $300 July toward housing costs. This was confirmed under oath. Appellant resided at the premises and contributed financially. He was never evicted through any landlord-tenant proceeding. On July 22, 2025, the only described incident involved a disagreement between appellant and another individual, not Ms. Shabazz, related to parking. Petitioner's witness, Carolina Gonzalez, testified she was outside, observed a loud dispute between appellant and a third party, and that Ms. Shabazz was inside and did not witness it. Ms. Gonzalez stated police were called and no arrest was made. The testimony repeatedly characterized the exchange as loud, but not as involving physical threats or violence directed at Ms. Shabazz. Ms. Shabazz admitted under oath that appellant never made physical threats against her and that her primary concern was that she wanted him out of the residence. She also described feeling emotionally unsafe and referenced past trauma. However, her descriptions of appellant's conduct toward her were not tied to the July 22 incident and were often based on generalized, non-specific, or second-hand accounts. Appellant testified that he contacted law enforcement concerning the parking dispute and declined to press charges. He further testified to the medical importance of maintaining residential stability. Despite this record, the court denied appellant's motion to stay enforcement of the protective order PO25028921, stating he had no legal right to remain or return, even though no eviction had occurred. The court also stated appellant took advantage of petitioner's kindness, although petitioner herself testified the living arrangement began because she needed rent assistance and appellant provided it. Legal argument. No predicate domestic violence offense was proven against petitioner because there was no altercation between petitioner and appellant. A protective order under ARS Section 13-3602 requires a qualifying relationship and a predicate offense, CARS. Section 13-3601. The only live incident, July 22, was a dispute between appellant and a third party, not petitioner. Petitioner was not present for that dispute. Without conduct directed at petitioner, there is no predicate domestic violence offense to support the order. 2. The evidence, even taken at face value, shows at most a loud argument, insufficient to establish disorderly conduct as the predicate offense. The testimony characterized the exchange as loud. Disorderly conduct under ARS Section 13-2904 requires that a defendant act with intent to disturb the peace or knowledge that disturbance is likely by fighting, unreasonable noise, or similar seriously disruptive behavior. A loud disagreement with a third party, without no fighting, no threats of harm, no intimidation of petitioner, does not satisfy the statute, especially where petitioner was not present to have her peace disturbed and no one was arrested. 3. Petitioner's own testimony negates the core safety rationale for the order. Petitioner admitted appellant never made physical threats against her and repeatedly framed her desired outcome as wanting him out of the residence. Protective orders address safety, not possession or occupancy. Issuing or upholding an order based on a desire to remove a roommate misapplies the protective order framework. IV. The court relied on subjective fear and hearsay rather than objective, incident-specific evidence. The record emphasizes petitioner's subjective fear and past trauma, and contains second-hand accounts of appellant's alleged conduct. But the July 22 incident, the only specific event, did not involve threats or violence toward petitioner, and petitioner did not witness it. The court's ruling elevated subjective fear over the objective, incident-specific proof required to show a predicate offense. V. Appellant's conduct was consistent with de-escalation, not intimidation. Appellant called law enforcement during the parking dispute and declined to press charges. That conduct is inconsistent with an intent to threaten or harass. No arrest resulted from the incident. V. The court's no legal right to remain or return finding is erroneous. Appellant remained a lawful resident absent eviction. Appellant was never evicted. He testified to paying rent $300 for June, $300 for July, and residing at the property. Landlord-tenant law, not a protective order, governs removal from a residence. Using a protective order to bar a lawful resident from his home, without an eviction proceeding, converts a safety remedy into a de facto eviction and raises due process concerns. 7. The record contradicts the court's finding that appellant took advantage of petitioner's kindness. Petitioner testified the co-residency began because she was short on rent and appellant offered financial assistance, which is how the arrangement was formed. That sworn testimony directly undermines the court's adverse characterization and supports appellant's good faith basis for residency. 8. The court failed to weigh the medical hardship created by barring appellant from his residence. Appellant identified medical needs requiring stability. Where the evidence of a predicate offense is weak or absent, enforcing an order that disrupts medical care and housing imposes a disproportionate hardship and constitutes an abuse of discretion. Ix. Burden and standard were misapplied. Petitioner bore the burden to establish, by a preponderance of the evidence, that a qualifying domestic violence offense occurred and that continued protection is warranted. The record shows no altercation between petitioner and appellant, no physical threats, and only a loud dispute with a third party that petitioner did not witness. On this record, the burden was not met. Reverend Tironi Smith. 5,208,395,066.